Now, you will notice that at the tail end of that exhibit, you find the summation of the total figures of votes that each candidate obtained. And you also indicate what, from your calculation, each candidate obtained. On the side, that there's a difference of 568.
Yeah. Yes, my lord.
That's all. Now, so let's look at the total valid votes obtained by the second respondent on that spreadsheet or summary sheet. Yeah. It is 6,776,065.
My lord, it's 66. I see 66 here.
66, sorry. Is that correct?
Yes.
And the total number of valid votes obtained by the petitioner is 6,265,276.
Yes.
Correct. And
6,265,276. Yes.
Yes. And from the EC's calculation, based on the EC's total valid votes of 30,218,600. What is that? No, my lords, that is the NDC. The last column is the NDC's votes. The EC's calculation of total valid votes is the column 1, 2, 3, 4, 5 from the right. That is the EC's calculation.
And that's the total valid votes.
Yes, total valid votes, yes. And the number, the figure there, my lords, is 13,218,633.
Yes.
Yes. Now, you find that from the EC's calculation, 6,776,000 and 66 yields a percentage of 51.261. Correct?
I will declare it up.
Excuse me.
I didn't understand the question.
I'm saying that if you look, it's your exhibit.
Yeah.
And I'm saying that from that exhibit, the total valid votes cast overall, according to the EC, is 30,218,633. That's the document. That's what you have.
13,218,633.
Yes.
Yes, and this is different from what was announced and what was corrected and what was subsequently corrected.
Please, hold on. So, I'm saying that 6,776,000 and 66, which is the total valid votes obtained by the second respondent, as a percentage of the overall total valid votes of 218,613, is 51.261%.
That's correct.
Yes. Now, you claim you did your own calculations of those figures. And by your own calculations, you claim that the second respondent obtained a percentage of 51.263 of the total valid vote cast. That's your calculation. You see it at the last column, at the bottom, the very last column.
Yes.
So
51.264.
263.
263,6759.
Okay. So I'm putting it to you that whether it is the EC's calculation or your calculation, definitely second respondent crossed the threshold.
If we are going by the data supplied by EC.
Yes.
But the data is internally inconsistent.
Now, let's now come to your exhibit. Your exhibit C. The cancer, no.
It was
Struck out.
struck out, yes. So
Yes. Now let's come to your exhibit. Your exhibit D. Now, your exhibit D is your famous letter
Yes.
of complaint to the chairperson of first respondent.
Yeah.
Where you claim that the results which were collated and signed by all the parties were not the ones transmitted from the region to the Electoral Commission's offices in Accra. And your second allegation was that Ashanti... No, my lord, I'm talking about the letter, Exhibit D.
what was the letter addressed to you?
It was
Was it addressed to the second respondent?
Yes.
This letter?
It was addressed to the first respondent. My lord, this is
You go on,
Exhibit.
go.
Now, you said two complaints, complaint A and complaint B. Complaint A is that in the Eastern region, the results in the presidential elections which were collated and signed by all the parties were not the ones that were transmitted from the region to the EC's offices in Accra. And the second point, B, relates to Ashanti region. Say Ashanti region provides fundamental problems that require investigation. We have found out that almost across board, the aggregates on the summary sheet do not reflect the individual results on the pink sheets. Further, the results collated and declared for the region do not reflect the aggregate results on the pink sheets in our custody. Now, it is a fact that you wrote this letter on 9th December. And I believe 2020. Is that not so?
Yes, 9th December 2020.
And I understand from your position that you wrote this letter before the declaration was made.
Yes, my lord. Okay.
So, Mr. Nketia, I'm putting it to you that your petition, your petitioner's petition, shows no reasonable course of action. Please. And I'm putting it to you further that you are not, the petitioner is not entitled to any of the reliefs that he seeks. And you have no case worthy of hearing before this court. My Lord, I'm done.
Yes, yes, please, there will be a question from the bench.
I want to be very clear on some issues. General, I know that when you purchase a pen drive, it is empty. And the data on any pen drive is generated by someone. So the pen drive that you attached to the hard copy and exhibited as Exhibit F, who generated or placed the data on it? Because when you were asked, you said you don't know what was on it. Who generated the data on the pen drive?
My Lord, as I said, honestly, I hadn't seen the pen drive and its contents till today. And I was relying on the hard copies. But the evidence is gathered by our Elections Directorate and the Legal Directorate.
So they gave it to you and you exhibited it as part of your evidence?
No, I did not exhibit that document.
As part of the petition. He did not exhibit it. He made it quite clear.
Exhibit F.
Statement.
So he swore on oath that it's for him, and he brought it to us.
He exhibited it. So I want to find out who generated it. So it means your election generated it and gave it to you and you exhibited it without seeing it.
Hard copies of the document because of the time pressure. I was discovering this thing today.
Okay,
So that's why I indicated that I haven't seen it.
Then I want to be very clear on these issues too. Very, very important to me. Now, in all the figures that were mentioned as the valid vote cast and all those things, you were saying if the figures were correct, and that there were inconsistencies in the figures, I want to ask you, now, in your own calculation, what were the total valid votes cast in the presidential elections on 7 December 2020? In your own calculations.
My Lord, those calculations are reserved for a meeting for us to reconcile the figures, because the first respondent herself keeps changing the figures. And so it is when you bring your...
Excuse me, Mr. Asiedu Nketia, help the court. You see, when you started giving evidence, you said you had all representatives across the 275 constituencies. You said you put agents to use the... Yes, and they were to, collect the figures. You said it. Then he's asking you that from that, what figure did you get? You.
My Lord, I haven't brought that figure to court.
Okay. Then, from your own calculations, what were the valid votes cast in favor of the petitioner, to your knowledge?
My Lord, when we discovered this discrepancy, it was difficult to even know which figures are.
You don't know, you just answer. You don't know.
I don't have them here.
Okay, then the last one. What figures from your own calculations did the second respondent get as the total valid votes cast in his favor?
My Lord, I don't have those figures here.
Thank you. That's all.
Mr. Asiedu Nketia, you have referred on a number of occasions to data being internally inconsistent. Can you explain what you mean by that? The data on the basis of which you have been cross-examined. You have kept saying the data was internally inconsistent.
My lords, there's no ambiguity in that statement. Nothing has been said here that suggests that there's no understanding of that statement. The statement is clear in its terms, so he cannot be asking him that question under re-examination.
My Lord, I believe the purpose of re-examination is to clarify matters that came up in the context of the cross-examination. So when the witness keeps saying that data is internally inconsistent, I believe that there is a need to explain.
My Lord, my understanding of data that is internally inconsistent is where figures are given and a total is given which is different from the sum of the figures. As we had on the declaration sheet for Eastern region, for instance.
What, my Lord? He hadn't finished.
No, my Lord. The answer is that data, which is, if data is given, and a total is also given, and when you add the totals, you add the data, raw data, it doesn't agree with the total as given, then the data is inconsistent. And I'm citing an example of the Eastern Region Collation Sheet. My Lord, it was said in court here, we tendered 2 different documents. One was done
you see,
on
this is just
6:40 p.m.
Excuse me. You want to elicit an answer to a very simple question for him to explain inconsistency in data. But going back to Eastern Region and flipping through the exhibits, yes, are you looking for fresh evidence? He wanted just a simple answer for you to tell the court what is, yes. Yes. That's all.
My meaning is that when there is data,
We've got it, thank you.
and there is a claim that the
We've
data
got it,
adds
thank
up
you.
to this, and when you actually add, it is different from what the total is claimed, then that data is internally inconsistent.
Mr. Asiedu Nketia, in connection with the cross-examination of counsel for the first respondent, he drew your attention to something from Ayen Swanu, and he related that to the calculations that he had asked you to make. Now, how does the Ayen Swanu
my lords, I object to this.
well, counsel for first respondent referred to Ayen Swanu in connection with the documents that he cross-examined you on.
Yes,
and my question simply is, what is the relevance of, can you explain the relevance of Ayen Swanu?
My lord, this is fresh evidence.
I'm sorry.
I want to make about understanding the rules.
Yes.
Thank you, my lord.
Oh, yes.
Or what? Okay.
It's off record. You didn't tell us your other name. You did not tell us your other name. Your alias, which begins with a rank in the army. You didn't tell us your alias, which begins with a rank in the army.
My alias.
Yes, which begins with a rank in the army. Or you don't want us to take judicial notice of that?
My lord, I thought Justice Apau prefaced his question with that.
Because you come from his hometown, that is why.
I'm known as General Mosquito. alias. Very well, my lord, if you request. Thank you very much, Your Lordship.
The petition is adjourned to tomorrow at 9:30 a.m. Yes. For the next witness.
All rise.
It's been another contest between Mr. Kufuor's lead lawyer, Akoto Ampao, and Mr. Mahama's first witness, Johnson Asiedu Nketia, in this cross-examination. Questions: was a fatal inconsistency exposed? Was the witness' credibility exposed? Or did Akoto Ampao test the petitioner's case and prove it was wrong, unreliable, unattainable? Well, the law, it is said, is in the bosom of the judge. We will wait for the 7-member panel's decision. But it's been a very long day, very long hours. It appears in all we've done close to about 5 hours, Kojo.
We have indeed. And I've got to say, for the last 2-hour stretch, the most fascinating moments for me was when the judges took a moment to ask a few questions. And I think it started to let us see perhaps how the court will be viewing the outcomes of all of these exchanges in order to make their ruling, their judgments at the end. And I think one thing is clear. They want to know what you are bringing to court for them to judge. They want to know what evidence you are bringing to court to make your case. And I noticed they were stressing on specific details. They wanted to know what are the NDC's own figures? What are they calling the outcome or the correct outcome? If they are identifying incorrect ones, what is the correct one? I could see that to be perhaps what the court was seeking to clarify. In the end, the witness had to say that he didn't have those details with him. And I don't know what that means. I don't know whether that in any way affects how the court will look upon the case that the petitioner is bringing. The fact that the petitioner is not himself testifying has again demonstrated its significance, because there are a number of things that in Mr. Akoto Ampao's cross-examination he sought to clarify, which appeared to be something that the petitioner would have to address. Even though this witness is one that is testifying on behalf of the petitioner, it was quite clear that there were certain things that the petitioner, the witness considered the petitioner a better person to address. So once again, the fact that the petitioner himself is not the one on the stand has proved to be significant, interesting. We will see how it affects the final outcome.
All right, so today's proceeding has ended, at least in the courtroom, but as we have learned today, what happens outside the court, especially where lawyers involved in the case are concerned, is also crucial. So who will address the media on behalf of the second respondents? As we've heard, and also seen, Frank Davis, the man who usually does it, was cautioned. The court said it was uncomfortable with his utterances and that it breaches the rules of the legal profession. Who will your money be on? Who's going to be addressing the media?
I wonder. Well, I mean, there are a number of people who could do that, people who are not on record as, advocates for the second petitioner. even Kojo Nkrumah, who is a spokesperson for government, often attends court. I've seen him there a number of times. I wonder whether he will be interested in taking up that role of communicating to the press on behalf of the team, on behalf of the side of the second petitioner. Yes, I think the court has made it quite clear that they've been paying attention to what's happening outside their courtroom, and they take a view of what lawyers are saying when they leave the
Could it also be that they were probably watching Newsfile because that issue was, came up strongly? There was Dennis Jima, who was on the show, who actually did say that perhaps the court, should caution lawyers on the case.
Yeah.
There were also some words to those lawyers who are not necessarily part of this case in the courts. So Justice Anini Yeboah, on behalf of the courts, made a passionate appeal that if you are a lawyer and you're not actively participating, put down your robes and grant the interview. That in addressing the media, one should not be in robes with the wig on. Fascinating.
Fascinating. And again, I mean, I've always wondered about these robes and wigs, and but it's a tradition that's particularly Justice Anini Yeboah, as the Chief Justice, respects and reveres. Certainly wants to keep in place. So yes, you can understand why they would take a view on that. I personally, I mean, I wish.
All right. Kojo, you are right. Kojo Nkrumah is addressing the media on behalf of the second respondent. We will listen in.
So let's know when you're ready. Yes. You are? All right. So good afternoon. I'm very sure you have followed the proceedings in the wells of the Supreme Court from morning till afternoon. We are of the view that it's been a good day in court, and that today the big word is exposed. Exposed. You'll notice that counsel on our side spent a lot of time exposing the inconsistencies and sometimes even outright falsehoods that have been put out by the petitioner and the witness who was in the witness box today. So when you juxtapose the earlier claims of we won now to what they are saying in the witness box about they don't know who won, when you juxtapose that to some of the tapes we played about claims of 51% on their side, now to claims that they did not even bring numbers to court, if you juxtapose that between their petition that talks about vote padding of a certain number and now a claim that it's only samples of that number, one of the first things that counsel on our side sought to do today was to expose the inconsistencies and sometimes outright falsehoods that have been peddled by the petitioner and the witness who was in the witness box today. Our counsel also spent a lot of time exposing the bad faith and prejudice with which the petitioner and his team have approached the work of the Electoral Commission and the chair of the Electoral Commission, Ab initio. And that's why you saw them take time to set out right from her appointment, from registration, etc. And the belief on our side that this is just a culmination of the various attempts to undermine an otherwise very good job that has been done. Also exposed through very vigorous cross-examination is a claim that was being made that nobody actually won this election. And that's why you saw the Venerable Akoto Ampao over and over again now raise the numbers and ask the witness to do the computation. And if you fry it, you bake it, you turn it upside down, you cook it, it is still 51% plus for the second respondent and about 47% for the petitioner. And you saw him do the maths and admit himself in the witness box when he was under oath. What we also found interesting were the attempts to shield the witness by his counsel to an extent that even materials that they had tendered in, there was an attempt to ensure that he was not questioned on it, even at re-examination, attempt to adduce fresh evidence. But I think you saw how the court handled it. The very final exposure we saw today, an exposure on the lack of candor. You heard the 3 questions that the bench asked. That for all that you have said, when you finished your collation, what were your results? When you finished your collation, what were the results that the petitioner got? When you finished your collation, what were the results that the second respondent got? And it was, I believe it will be very surprising to the millions of NDC supporters across the country who were egged on by the same team that they had numbers to prove they had won. Now here in court, when the bench asked those questions, they say that they did not come to court with any of those numbers. They are not still able to put any numbers before the court, despite all that they had said. So for us, in summary, we're of the view that it's been a good day in court. You saw the lack of candor when on the soft copy on the pen drive, they had made notes that they observed what they call padding, both for the MPP and the NDC. Yet they had claimed that there was a deliberate attempt to steal this election for the MPP. And now in their witness statements, they sought to delete those ones out. And then when it was put to our very good friend, the general, he now said he was not responsible for the pen drive, etc. So that exposure of the lack of candor is also one of the things that our council sought to do. In conclusion for us today, our view is that if your case is bad, even the most skillful general will be exposed at cross-examination. And that's what we believe has happened today. If you have questions, we'll take them now and then we'll wrap up.
Your side sought to tender in exhibit through the petitioner's witness. They were opposed to it. Why did you want to do that when you had not asked the leave of the court first?
Well, so that will be a technical legal matter. The substance of it, however, is that what we wanted to show was still in the video that had been submitted. And so you saw our counsel find an opportunity to now cause the witness to do that calculation and express it as a percentage. And no matter how you do it, it still comes back to that same point. The second respondent, 51% plus, and the petitioner, about 47%. Any other questions? Well, we thank you. We'll do a quick translation in Twi, and we look forward to tomorrow's engagement in court.
And that's Kojo Nkrumah. He's actually one of the designated spokespersons on this case for the second respondent, Nana Dankwa Akufo-Addo. In all, he says, exposes the word for them. Today, out of today's hearing. Good day in court, Kojo Singh. That's what Kojo Nkrumah says, and he actually settles on those three questions that Justice Eninyebua put to the witness today. In your own calculation, what was the total valid vote cast? What figures did Mr. Mahama get? What figures did Mr. Akufo-Addo get? And we know the answer to that. He says he didn't carry the figures with him. And
who compiled the data on the pen drive? Another question that was not answered by the witness. Well, the witness did answer. Said that he hasn't had the opportunity to go through the contents of the pen drive. So yeah, I mean, what else would you expect?
It's been brief today.
It's been brief. It has. I think perhaps that might also be more of the style of the person who spoke on behalf of the team. Kojo Nkrumah does tend to prefer to get straight to the point. His predecessor was a bit more of a storyteller, a bit more of someone who would elaborate on issues. Mr.
Also,
Nkrumah,
perhaps tolerated a lot more questions.
Perhaps. I think today it did appear that he called for questions. It didn't seem as if there were any forthcoming, because he did say, "Are there any questions?" But then that was a wrap very quickly after that. Where I suspect that the EC chairs, the EC's lawyer will be next to speak. But I think in focusing on the questions that the judge asked, another thing that it does is that it moves the commentary away from us versus them to, well, this is what the court is after, And I suppose in a certain way that's also good, strategy-wise, for the second respondent's team, because what it means is that it's not even us saying this. We are not asking you to believe our interpretation of what happened. We're saying, look at what the court was asking for. Look at what the court was saying. In terms of communication strategy, I can see how that is perhaps an effective way of going about things. Whether it'll work or not, that's to be seen. But one thing is for sure. In this first salvo of questions from the court, we get a taste of what they are looking for. Whether the petitioner will satisfy these things, time will tell.
Absolutely. Well, we'll wait to hear from the side of the petitioner who will be addressing the press as well. We'll take you there when they get ready. But our election petition update is brought to you in association with Petrosol. Clean fuel in full quantity is always a delightful experience. Also, DBS Roofing. We truly are your roof experts. COA Mixture, the immune booster for your general well-being. So after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of Colorlink Plus roofing sheets in 26 years, which means Colorlink Plus roofing sheets always stay clean and beautiful for you. And there's more. They're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited in Accra on the Spintex Road in the DBS building near Papaya. You can call their hotlines 024-8084-4444. That's 024-084-4444 or 054-3286-637. Or visit the other factories in Kumasi, Tamale and Takra. The DBS Industries Limited. We truly are your roof experts. Now, due to hard times, we've become value hunters, but are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart, hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us, Petrosol, clean fuel in full quantity. So finally, Kojo, General Mosquito, Asiedu Nketia is done with the cross-examination.
Yeah.
How has it been? I mean, it's been more than a day because he started on Friday, ending today.
I suspect that following the pedantic, painstaking, grueling cross-examination of lawyer Akoto Ampao today, General Mosquito, as he identified himself to the judges in that light moment at the end, he's going to be quite relieved to be able to stretch his legs, get himself a drink of water or whatever it is that he'll need to calm himself at this point, because that was intense. That was intense. I mean, especially compared to Friday's cross-examination, which he seemed to be very relaxed during. He seemed to be more in control of that than today's, where Mr. Ampao insisted on wresting control from him at every
We're going to go back to the court now. Marietta Brew, Apia Opong speaking.
He has said undermines our case. Indeed, everything he said goes to points to the fact that we are entitled to the declarations that we are seeking. But several interesting things stood out today. Let me start with the video. The video that they sought to show to try and dent the credibility of the General Secretary didn't happen as they thought it would. In the end, his credibility rather soared. If you watch the video, and I'm sure you all watched it, it is clear from the video that he never said at any point in time that the petitioner had won the elections. In fact, what he did were projections, and rightly so. He stated that based on the 141 parliamentary seats that we had won, the projection was that we would win the presidential slot as well. Those were projections he made. And so they were unable to show from the video that the general said what it is they were trying to prove. So of course they flopped in that regard. The other thing that came out clearly was that there were ever-changing figures from the general's testimony. Now, from their own cross-examination, they described these ever-changing figures as manifestly erroneous. We had the 9th December figures of 13,434,574, 10th December 13,119,460. Then in their paragraph 24 of their answer, that's the first respondent's answer, she talks about 13,121,111. Yet again, today, there were corrections made. And we saw that from the cross-examination on Techiman South. On the face of that, their own exhibit, it showed 97,227. But when they did the tally or the collation, it was 99,436. So when we make the point that based on their own declarations, that's the EC's own declarations, there are errors, we are right. And it has been proven by the cross-examination that they conducted that we do not know what the figures are. Based on her own declaration, nobody got more than 50%. And the declaration I'm talking about is the 9th of December declaration. Also important is the issue of padding. They cross-examined the general on the issue of padding. And you can sense from the cross-examination that they admit that there was padding. What they tried to portray was that on a pen drive, there was an indication that there was also padding in favor of the NDC. Now, if they admit that there was padding, then obviously we are dealing with a very flawed election. That is the point, and they admit it. It's a clear admission of a flawed election. And he also made the point that what we attached in terms of padding were only samples. Only samples. So you can't take a sample and deduct it from a whole or an absolute number and get any results, because that sample is simply what it is, a sample. In the end, there were also questions from the bench about our own figures. But I think we need to make it clear, and it's been made clear over and over again. We are here challenging the EC on its own figures. Its own figures. What are those figures? There's the 9th of December, there's the 10th of December so-called correction, and there's also the figure in their paragraph 24. And then today we realize that even in some of the constituencies, and they themselves brought out the example, Techiman South, there are errors. So if you ask us, what are our own figures? How are we going to get our own figures based on all these flawed sheets and different figures? And so we stand by what we are saying, that based on her own declaration, nobody got more than 50%. So today we are happy with the cross-examination of the general. We are happy with the results, and we think that our case was made clearly in the court today. So if there are any questions.
Yes. Sisters.
Yes, the interest in the alternative figures, as the petitioner would have or should have brought to court, maybe it's not a matter of interest to only the bench. A lot of us journalists followed the election keenly, and we know that on all sides, the NPP, the NDC, the CPP, each political party had, call it a collation center or a tabulation center, whatever the name was. But each political party was able to, following the reports from their representatives at the polling stations, tabulate the figures, and at the end was able to tell whether or not they were leading, they were behind, whatever the case may have been. Is it the case that based on the tabulation that the NDC did of the election results, it is not possible for the petitioner to tell us some figures which probably directly contradict the figures that the EC chairperson announced on the 9th of December?
I mean, that's a good question, but having regard to the case we have even brought to the court, I don't even think it's necessary. They themselves have different contradicting figures. Why do you need another one from us? They are different contradicting figures. And that is the point we are making, that the EC themselves, what are the figures?
Yeah, any other? Akabile?
On the point about the alleged vote padding, I just wanted to find out, because we heard General saying sample. I mean, what is the full range of this vote padding that the petitioners team detected? And if indeed you detected that full range, should you rather not be making the case that those votes be annulled? And the other one relates to General's point about the first time he's seen the contents of a pen drive. If you could clarify that point for us as well.
Okay, I think let me start with the issue of the pen drive. The information on the pen drive was printed for the General. It was printed for him, so he saw the hard copy. He didn't actually see the pen drive, you know. And from what I could see on the screen, they were actually reading from the names of the folders, which he would not have. He would have the printed document, because of interest to him was the information on in the documents and not the names of the folders. So that is how it is explained that way. It's not to say he didn't know what was in the folders, but what they read was based on the names of the folders. I hope that is clear to you. Then the other question was what?
The vote pattern. Yeah.
Why did you bring
more?
That's not a case in court.
That's not fundamental to that.
Because you kept saying sample, and the sample came to 4,000 in terms of General's witness statement and about 5,000 in terms of the petitioner's statement. The full range that you discovered in your analysis, how many votes are we looking at, and why are you not making a request with evidence to have those votes annulled instead of relying on the declaration of December 9?
Well, that is the choice that we made, that we will challenge the declaration of December 9. That is the choice that we made. We brought samples to show how flawed the election was, but our choice was to challenge the very declaration of December 9.
Okay, we can do the P now.
Yep.
Is that okay?
Okay. Okay. Yo, abusian for
So both sides are happy. Kojo, we've heard from Marietta there, and they both have won.
Yes, well, I mean, they can't both be right. But it's fascinating to see the perspective that Marietta advances on behalf of the petitioner. Okay, so she thinks that the videos that were shown in court actually went to confirm the witness's credibility. Now, I can see where she's making that conclusion from, because the main thing that the witness was accused of was of making a declaration that their candidate won, that the petitioner won, and then coming to court and claiming that nobody won. That is what Mr. Ampao had sought to, if you like, discredit with the videos. And watching the videos from beginning to end, there was no instance where Mr. Asiedu Nketia himself declared that this person won. There was a part that Mr. Ampao sought to translate to mean that. The petitioner insisted that that's not what he meant, and that he was just making a projection. But it's fascinating, because there were some very clear statements that the petitioner has won, made by others, like the deputy, I believe his deputy...
Peter Otukno?
Mr. Peter Otukno. And the question then comes, as General Mosquito himself says, he's the CEO of the party. So the question will have to be considered by the court. Does the CEO take responsibility for the statements made by other officers? I mean, if a deputy minister makes a statement and the minister doesn't correct it, can he later in court distance himself from that statement? And then finally, the NPP... the second respondent referred to the pen drive in court. Marietta says this means the second petitioner is admitting that there was padding. The general said that the information they've provided, the evidence they provided, is just a sample. So the question is, will the court rule on just a sample and determine that there was more or not? I mean, if you bring evidence that Mamavi killed 2 people, will I then decide that it means that the 8 other dead people were also killed by Mamavi? We'll see how the Supreme Court deals with these things.
Absolutely. Well, thanks for using our hashtag election petition. We're grateful to Petrosol, DBS Roofing, and Koa Mixture for bringing us the election update. Join us tomorrow at 9:30 when the court sits as it continues with its cross-examination. I am Mama Vio Swabwaje, been here with Kojo Yankson. Gifty and Apia comes up with polls. But first, here are excerpts of Mr. Asiedu Nketia's testimony today.
The thrust of all these statements in the various clips is that President Mahama had won the 2020 presidential election.
My Lord, these statements, according to the videos, were made at different times.
I didn't ask you when they were made.
Some of them were made after declaration, some before declaration, and so on. So it is difficult to put all such together and say that at this point, this was what was said.
No, I'm putting it to you that these statements were made before declaration.
My Lord, my viewing of the video indicates that some of the statements were made after declaration.
Even better. And so you admit that some of the statements saying that the petitioner had won the elections were made after the declaration. Not so.
From what I have watched here with everybody here, I can see that this is not a video of one event. These are videos picked and pieced together, and some of them relate to a time period before declaration, and others relate to a time period after declaration.
Now, it is no secret that interspersed between these press conferences, the NDC, under your direction, had organized several demonstrations in Accra, stating that the petitioner had won the election and warning the first respondent not to subvert the will of the people.
My Lord, the NDC had organized several demonstrations with three main objectives. One,
please, I've not asked you for
the killing of innocent voters at polling stations by security officers, and nothing seemed to be happening. The NDC made that was one of the purposes of the press conference. The other purpose of the press conference.
Please, I have not asked you the purpose, so answer my question. Please, and don't be taking instructions.
Can you restate
Don't be taking instructions from, lawyers on this side. Please.
Please, let's observe. Please, Deacon. Please.
My Lord, I know what I'm talking about.
We are closer to them than you. We've not witnessed anything. Please.
Yes, please answer my question, and you had your opportunity to write your witness statement. So now you answer the questions. You understand?
Please, I'm asking the question again, and I answer according to my ability and what I consider to be the answer to the question.
I'm saying that interspersed between these press conferences,
yes,
the NDC organized a series of demonstrations, the object of which was to...
The thing is loaded. You see, it is double barreled. Can't you break them?
Organize a number of demonstrations. Is that so?
Yes, we did.
And one of the clear objectives of these demonstrations was that the petitioner had won the elections and the EC should not subvert the will of the people.
My Lord, the objective that relates to the presidential elections was that the results as declared were flawed. And the commission itself had accepted that the results were flawed, and that's why they kept changing the figures.
So you admit that you said that the results were flawed.
Yes.
Who, in your view, won the results? The elections?
My Lord,
who?
We are not interested in winning or losing a flawed election.
Very well.
We want the election, we want to be winners of an election that is credible.
Now, it is also true that notwithstanding all these statements that your party, yourself, and the petitioner had made, that the petitioner had won the election, when you eventually filed your petition, there was nothing in the petition about the petition having won the election.
My Lord, I have indicated earlier.
No, please answer my question.
Please, I'm about to answer the question, unless you are not ready to listen to the answer.
I've asked you that when you filed the petition.
Yes, my Lord.
Yes. There was nothing in it to the effect that the petitioner had won the election.